Well, I'm always happy to get to spend a few minutes talking media law with one of the very best in the business, Leita Walker. Leita is a partner at the Ballard Spahr law firm up in Minneapolis, where she represents news media clients in disputes about access to information and the ability to publish. And she has a background as a journalist going back to her college days at the University of Kansas, where she was the editor of one of the best college newspapers in America, and then graduated top of her class from the law school at Kansas. So welcome, and thanks for sharing some of your expertise with us. And maybe you could just start with, I gave you a very quick introduction there. Tell us a little bit more about you and about your practice.
Sure. Well, thanks for having me. I'm envisioning a classroom of students, and hello. Thanks to all of you for listening. Went to journalism school. Yes. Thought I'd become a journalist. Married a journalist, and we sort of looked at each other in 2003 when I was graduating and realizing it was hard to find a job in newspapers. The industry was changing. He was a copy editor. I was a reporter. It occurred to us we'd never see each other. And I said, well, why don't I take the LSAT and see what happens? And I thought at the time I would either teach media law in a journalism school, or maybe I'd be the next Adam Liptak, right? And get a law degree and go report on the Supreme Court or something. But it turns out I liked being a lawyer. I liked being a litigator. And so I became a lawyer, but always wanted to do media law, and have been lucky enough for the past 15 years now that I've been a lawyer to get to do that, even in a Midwestern city like Minneapolis. And especially a lot recently, because Minneapolis has been the epicenter of a lot of stuff that I think we're going to talk about here for the next 20 minutes or so.
Yeah, we absolutely should. So before we get into the recent cases that you have been handling, we should lay a little bit of legal groundwork for folks. We talk a lot in the class about the First Amendment right to publish information, and how the courts have been emphatic that the prior restraint doctrine forbids the government from telling journalists what they can and can't publish or put on the air. But the First Amendment right is not nearly so clear when it comes to the right to be someplace where news is happening. That right is not nearly as well developed. But we do know quite a bit about the First Amendment right of access to judicial proceedings. So maybe you can tell us a little bit about what the courts have said. The First Amendment does guarantee cases like press enterprise when it comes to court proceedings and the right to attend and the right to inspect the documents.
Sure. So yes, to put it simply, there's a clear First Amendment right of access to criminal court proceedings and criminal court records. Many jurisdictions have also recognized a First Amendment right of access to civil proceedings and civil court records, but criminal is sort of the apex of access. And then beyond the First Amendment, of course, there's common law rights. And most courts across the country recognize a right of access through court rules. And so whenever I'm marching into court, either to get access to a hearing or a trial or an exhibit or a summary judgment motion or whatever the case may be, I always cite all three. Here's the court rule, here's the common law in this state. And then, Your Honor, if you must, here's the First Amendment if you need to go there. And the standard to overcome that presumptive First Amendment right of access is very high, right? You have to show a compelling government interest. You have to show that the restriction on access is narrowly tailored. And you have to show that the restriction on access is effective. And I think that's always an interesting one, because so often courts bend over backwards to restrict access, and it doesn't accomplish the purpose that they think it accomplishes, and happy to talk about that more. But those are the big three things that a proponent of secrecy has to show.
You actually mentioned the First Amendment right to look at and inspect the exhibits as well, which is really unusual, right? Because if I go to the mayor's office and I say, I insist on seeing your appointment calendar or your emails under the First Amendment, I'm not going to get anywhere, right? So how
Right.
has it been that the courts have recognized that there's an actual constitutional right to see those exhibits that are shown to the jury?
Yeah, you're right. I mean, the way we get access to documents that are in the hands of government agencies is through state open record laws, right? It's not a constitutional right. But there's been a series of cases, Richmond newspapers being one of the first, Press Enterprise being another, Press Enterprise 2, another, that basically hold that, what happens in the court is public property. And if it is a judicial record, it is presumptively accessible to the public. And so, and tell me if I'm jumping the gun here, but for example, in the Chauvin case, actually one of his co-defendants, there was the body camera footage was filed with a motion to dismiss the charges. This was Thomas Lane was moving to dismiss the charges against him. And the court made the body camera footage accessible, but said you have to come down to the courthouse to view it, and you can't record it. You just can look at it and then you can leave and go on your way. The body camera footage, although in the possession of the police and the state attorney, wasn't public under our open records law. So we brought a First Amendment based motion in the trial court and said, this is a judicial record. There's a presumption of access. It's a contemporaneous right, and it's a right not only to access, but to copy and disseminate. And we won. The court said, you're right. I can't make you come to the courthouse to see it. Call the clerk. She'll send you, a thumb drive or whatever of this body camera footage. And so that really highlighted the nature of the right and how it's very different in courts versus when the very same document is in the hands of a public agency.
That's a really big deal. And that is some very creative lawyering, I must say, because normally, like you said, when something is a criminal investigative record and it is in the hands of the police or the district attorney, that's it, game over. The public is not going to get to see it, possibly for quite a long time. But because this was also in the hands of the court at the same time, you had sort of a side door to go through when the front door wouldn't work. So very creative.
Yeah. And to get back to my point about the relief has to be effective, one of the arguments we made was there's a transcript of the body camera footage that was public. You could go and watch it and you could describe it. That was public. And so what is the advantage to keeping the footage itself secret? When keeping it secret probably is just going to lead to confusion and misquoting, and you're relying on the descriptions and sort of hearsay of people who've seen it, trying to, it becomes a game of telephone. And I think we convinced the court that show people the real deal, right? The relief you're trying to fashion here really isn't effective to keep information about the body camera footage away from prospective jurors and to ensure a fair trial. So just release it.
That's a really good lawyering point as well, right? That if you're trying to oppose secrecy in the courts, just showing that the secrecy is not going to have any practical effect because the public is going to find out everything that is in this record anyway. So why not hand over the record? That's a really convincing practical point. It's not kind of a legal doctrine point, but it's a more practical point that, look, isn't the best evidence for the public to see the document itself and not somebody's third-hand description of what's in it.
Right. Yeah, I always try to talk about, Your Honor, it's in the best interest of everyone, the defendant, the court, the prosecutor, and the media, for the public to get accurate information. And how do you ensure the information's accurate? You just let them see the exhibit, and you don't rely on journalists trying to scribble notes as they hear something in court to relay everything themselves. Just let the public see it.
Right. And I'm assuming some of your clients are probably broadcasters as well, right? So for them, scribbled notes are a very, very poor substitute for having the footage.
Yes, absolutely. One of the things that we pushed for, and it's shocking to me that you have to argue about this in 2021, is at least letting reporters have electronic devices in the courtroom for note taking. The federal trial of Thomas Lane, Alexander King, and Total starts next week. And at first, the federal court wasn't even going to let people have laptops for note taking in the courtroom. And we said, you've got to be kidding. People can't write fast enough, right? If you want it to be accurate, let them take notes on a keyboard. And he finally said yes. So, small victory, but an important one.
Yeah. Oh, I want to unpack that because you hit on two really key points. First of all, the distinction between federal court and state court, and also the ability to bring electronic devices of all kinds into the courtroom. So talk a little bit more about those two things. I guess, first of all, the ability to bring electronic devices, cameras, video recorders, my tweet machine, what is my right to bring those into court in general? And then how does that differ whether the court is federal court or state court?
Sure. So it's very jurisdiction specific. Federal courts across the country, no matter what state they're in, are pretty, they all treat it the same, which is to say they don't allow that stuff. They don't allow cameras. They don't allow video cameras. They don't allow still cameras. They tend to not allow live tweeting from the courtroom. A lot of courts, I think in New York, for example, you either need to leave your cell phone in your car or put it in a lockbox before you go through security. There are other courts in Minnesota that will at least let you keep it in your pocket. But if they see you take it out in court, if it's on, if you're connected to Wi-Fi and sending messages, unless you've gotten special permission, that is not permitted. So federal courts are very restrictive. State courts, it's sort of the wild, wild west. Florida and Wisconsin 30, 40 years ago adopted rules that permit cameras in courts and have really been a leader in that. I've got a case I'm working on right now in Wisconsin, criminal case. I'm just representing the media to try to get access and make sure cameras are there. But it's being live streamed. It's a murder trial. It's being live streamed. There's live tweeting from the courtroom, and that's just normal in Wisconsin. Whereas in Minnesota, the fact that the Chauvin trial was live streamed was sort of historic. We do not have cameras as a rule in Minnesota criminal courts. They're permitted if both parties agree, but it's rare that in a criminal case, both parties can agree on anything. And if they do agree, it's usually because neither of them want cameras. So we got cameras in the Chauvin case here in Minnesota solely because of the pandemic and social distancing requirements, and the judge finding that because of social distancing, they couldn't possibly provide a reasonable accommodation to the press and the public who wanted to watch the trial. And the only way to ensure the trial was open was to allow camera coverage. Minnesota is about one of 15 states, I think, that does not allow cameras at criminal proceedings. So it's a minority. Most states, and again, federal courts aside, most state courts allow it, but there's still 15 states that don't.
Wow. Yeah. And so federal court, it's just off the table. There's not even any reason to bother arguing for it because we know what their rules are. State court, it sounds like there's discretion for judges to allow it, not allow it, how much they're going to allow or how little they're going to allow. So how do you argue for that? Pandemic aside, COVID aside, because that does change the game and it changes the arguments. But in non-COVID times, what's your argument for why we should be allowed to have still cameras or video cameras inside of the courtroom?
Yeah, well, I've never really had to or gotten to make it outside of a pandemic because Minnesota Supreme Court rule has just been no cameras, end of story, right? And so the pandemic opened up a window, and we got it in the Chauvin trial, we got it in the Kim Potter trial, and the co-defendants of Derek Chauvin will be tried in state court in March, and we're going to have cameras there. And so what I'm hoping is that we can use those three trials to say, look, here were three very high profile, very contentious trials that created a lot of community passion where we had cameras and it was fine. Like the sky did not fall. And in fact, it was more than fine. It was a net improvement because 18 million people, maybe more, watched the Chauvin verdict. And I think and what I say to judges when they're skeptical of cameras, and what I'll say to the Supreme Court when we try to get the rule changed in the coming months, is we want people to have confidence in the verdict. We want them to believe in the system and to trust in the process. And people don't believe what they can't see. And you let them watch this unfold and they realize, oh, it's not like Law and Order. It's actually really boring. And the jury takes its job really seriously. And there's a lot of evidence excluded. And they see that it's so deliberative. And I think, and I hope it gives people more confidence in the system. And, you know, we didn't find out, but I think because the Chauvin verdict was televised, had the verdict come out differently and led to, you know, disappointment, I believe and hope that the unrest would have been tamped down a bit just by the fact that the people were able to see justice unfold. So that's always my big argument is, why should we trust our citizens to make decisions, and how can we have a democracy if we don't let voters and taxpayers watch these things? The other thing I'll say is, you know, your class is probably too young to remember the O.J. Simpson trial. I remember it. And people a generation older than me remember it as sort of a circus, right? And to this day, when you confront judges who are in their 50s and 60s about cameras, they'll say, oh, O.J. Simpson, we can't have another trial like that. To that, I say, you have no idea, Your Honor, how the technology has changed since 1993 or whenever that was. You're not talking about giant cameras wheeling around the courtroom on tripods with cords everywhere, tripping people. You know, in Chauvin, there were 3 tiny cameras, remotely operated. There was not even a camera person in the courtroom. And I think that contrary to creating a circus atmosphere, live streaming a trial actually keeps people home. They don't have to come to the courtroom. You don't have long lines. You don't have jostling for seats, especially during a pandemic, because people can just watch it like you're watching this, and it's super convenient. So my argument these days is if you're worried about a circus, live stream the trial.
That's really smart. I like that. Yeah. Well, we've already talked quite a bit about the Chauvin case, and we're sort of presuming familiarity with it because it's what we've all lived with for the last few years. But this is the case about the killing of George Floyd on the streets in Minneapolis by a police officer who is now a convicted murderer as a result of the trial that we've been talking about. And Derek Chauvin is serving a prison sentence. But also, as you mentioned, there are more legal proceedings to come against both him and the other officers involved in the death. So this is by no means over with. Maybe talk a little bit more about your particular role in kind of pushing for openness and access in all of these proceedings.
Yeah, so it even predates Derek Chauvin. We've had 3 officer-involved criminal trials in Minnesota, and actually in Hennepin County, which is where Minneapolis is, in I think 3.5 years. It feels like 3 trials in 3 years. Maybe it's a little bit more. The first was Mohammed Noor, actually Somali American police officer who killed a white woman and a yoga instructor, right? So talk about sort of a reversal of the racial dynamics that we've seen play out in so many other cases. He was convicted of 3rd-degree murder, and recently actually that conviction was reversed. And he was resentenced. So that was the first that I got involved in, and that was big at the time, but nothing compared to Derek Chauvin. That trial was last April. While that trial was happening, Kim Potter killed Daunte Wright. She meant to tase him, but accidentally shot him, and her trial just finished right before Christmas. The jury convicted her of 1st-degree manslaughter. She'll be sentenced in a week. And so there's been 3, and in every single one, you know, we've had to, on behalf of the media, I've had to intervene to ensure access to the proceedings. We didn't get camera access in Noor. There was no pandemic upon which to hang that hat, but access to access to the proceedings, access to evidence, camera access, access to jury names after the trial was over, and then triaging issues as the trial progressed with the court when problems arose. So an example from I'll give you a couple of examples, and there are lots of war stories, but in the Knorr case, for example, body camera footage is key evidence in all these cases, right? So in the Knorr case, there was body camera footage of the victim dying because Knorr shot her, immediately realized what he had done, tried to save her life. And so it was, very graphic, very traumatic body camera footage. And the judge in that case proposed that when that footage played in open court, the television should be turned so only the jury could see the footage. And we intervened and we said, absolutely not. That's a closure of the courtroom. Anyone in the courtroom should be able to see this footage, graphic and traumatizing as it might be. So we brought a motion, to intervene for that reason. We intervened in the Lane case, as I said, to get copy access to body camera footage. We intervened in that case because the judge briefly purported to gag the trial participants. So that issue has come up. The camera issue we've talked about. In all three cases, the jury names were anonymous, which is not the norm, and we don't think should be the norm in criminal cases. These people are, yes, conscripted into service, but playing a vital role, and we need to know who they are, and we should be able to talk to them after the fact about, why they reached the verdict they did and what was the evidence that swayed them. So we've moved to unseal jury names in all of those cases. And then, as I said, just silly little things came up during the trial itself. So during the Chauvin trial, security was very tight. The court wanted to be very considerate of family members. And so anytime a journalist who was covering the trial tried to talk to a family member in the hallway, these armed deputies would come up and say, "You can't talk to them, go sit over here." And so I would just get involved to call up the chief judge and say, hey, we have a First Amendment right to talk to a willing source as long as it's not disrupting court, which is in recess. And so, there were umpteen issues like that came up that were handled not with a brief, but just with a phone call or an email. And I think for me, and I'm kind of going on here, so feel free to interrupt. For me, the silver lining of that trial was we established a very solid line of communication with the chief judge for Hennepin County. And I think he learned a lot about how the media does its job. And he came to really trust the media. So many people don't. So many people don't understand what journalism is, how it gets done, what the media needs to be able to do things correctly. And so that was just a great development to be able to talk to him and say, they have a right to talk to people. Oh, they do? Yeah, they do. Oh, okay. We'll make sure they get to talk to people. And I will say that the Kim Potter trial, which happened after Chauvin, but in the same court with the same chief judge in the same building, all those issues, they went away. We had figured it out. And I guess my kind of closing point on this little question is, I can't underestimate how important it is for journalists and judges to get to know each other and work together and understand what each needs to do their jobs.
That's really smart advice. Real quick, because you raised this procedural point, and I do think it's important for people to understand, because after all, the case is going to be state v. Chauvin or people v. Chauvin. There's no news media parties in the room. So how does the news media get to be a participant here? You mentioned this concept of intervening. How is it that you get to go into court and stand in front of the judge and make arguments in a case that you're not a party to?
Yeah, it's called a motion to intervene. And in civil cases, there's a federal rule. I'm blanking on it right now. Federal rule and a state court rule that give you a right to intervene as of right, or a right to intervene sort of permissively. So we'll cite that in civil cases, but in criminal cases, courts have held that the media just has standing to assert its rights whenever restrictions on its access are put in place. And so we just file a motion and we cite that case law, and then we make our argument about why closure or sealing or restriction is improper.
So that intervening process, you get to be a participant in the case, at least just for that limited purpose. You show up and you're allowed to go into court and make arguments just like the lawyers for the parties are allowed to.
Correct. That's right.
Real quick, let me ask this, because you mentioned that sometimes the two sides in the case actually agree with each other that they'd rather not have TV coverage, or rather not have cameras, or maybe rather not have anybody in the courtroom at all. What are some of those interests there? Why would somebody not want there to be coverage, and how do you overcome the, it's my trial, how come I don't get to decide whether people cover it or not?
Yeah, I mean, I'll answer your last question first, which is, why should we let Derek Chauvin, maybe the most notorious criminal in Minnesota history, to decide unilaterally under Minnesota rules who gets to see justice done in this case that frankly shook the world? Like, why should it be his decision is sort of my answer to that. The police cases make really strange bedfellows. Typically, it is the defendant who objects to camera coverage because this is the defendant's, it's the worst moment of his life, and he doesn't want it on television. And I think that's understandable. In the Chauvin case, all of the defendants actually wanted camera coverage, and they never told me why, but I suspect it was because they felt like they had already been dragged through the press. Their reputations couldn't get any worse. And maybe camera coverage would allow the public to see them as, somewhat sympathetic individuals. It was the Attorney General in the Chauvin case who objected to camera coverage, and the judge overruled the Attorney General's objections. I think it's a travesty that the Attorney General, who's supposed to represent the public, took that position. I think they should be for transparency at all times. But I understand that as litigators, they just want control over, they just want control. As a litigator, and I'm a litigator, you're trying to eliminate all the variables that could possibly go wrong. So you limit the set of stuff you have to worry about. And I think they just saw it as like one more thing that could go wrong. And so let's not risk it. The other thing people will say is that cameras make witnesses very leery. And they say that witnesses are less willing to testify and not as forthcoming. My response to that is you can subpoena them. And I think cameras make people more honest and more forthcoming because they know they're being scrutinized. And if they are evasive or deceptive, everyone is going to see it. So I just don't buy that argument, but I am sympathetic to the notion that some witnesses shouldn't have to face this. And so in the Chauvin case, for example, some of the children who witnessed the crime and who testified, they weren't on camera. And I think that's a fine decision.
That makes a lot of sense. Well, Leita Walker, I want to thank you again for sharing really dispatches from the front lines of the First Amendment with us. You are right out there pushing the boundaries to make good law that protects the safety of journalists and our ability to stay informed. So thank you for doing that. And thank you for sharing your time with us.
Oh, thanks for having me.